Hello, my name is Caden. This is Castle Tutelage, your home defense network. I'm going to be right up front. This is going to be one of those videos that I just don't have an answer to, and it's going to be a rhetorical question on my part, but I'd kind of like to know the answer to it also. The question being is that if you are concealed carry at, let's just say, a Minnesota Twins game, okay, you cannot carry a handgun to the stadium, all right? And you were coming out, an event happened just outside the gate, you defended yourself. Are you in legal peril of having a non-defensible court case? Okay, this is what I'm going to be getting to. There's been some comments basically are saying that people go into places where they cannot concealed carry or legally concealed carry. In Minnesota, we have a quasi-enforceable no gun, banning guns sign. But then there is a second step where you have to be escorted off the property. But that's not what I'm saying. If the law says that you can defend yourself anywhere that you are legally able to be, a street, your home, a park that allows it, that kind of a scenario where you are legally able to be there with a handgun. So if you are coming out of the Minnesota Twins Stadium, you defended yourself, you were the innocent victim, you were an immediate threat of death or great bodily harm, you used proportional force only to stop the threat, there was a retreat consideration and there was none, and you met the reasonable person standard both subjectively and objectively. You defended yourself or a family member. The person died that you shot, but since you weren't able to legally have a gun there, does that make you not an innocent party anymore because you broke the law? Same thing goes if you go into a store, private property. Even some states you need to have if you go to a friend's house, you need to have that friend's authorization to enter your property with a concealed handgun. Let's just say it was Christmas time, you went to a party, and the daughter's boyfriend breaks through the door, and you shot him, but you didn't have the property owner's permission to have the gun there. Are you opening yourself to legal liability? This is a question I have. I don't have the answer to this. And then again, I'm not going to pay someone $360 an hour to tell me the answer either. So I don't know. Am I confusing some people? Some people accuse me of giving a bad advice, confusing people, but this is clearly outside my wheelhouse of I'm not going to say expertise because I am not a lawyer. I don't pretend to be, but it's definitely outside my realm of knowledge, and it'd be interesting to know. There is something called the doctrine of necessity, where if you are in a street and you went onto someone else's property that was posted no trespassing, and you completed your self-defense there, it's to say the original thing happened in the street, in a public street, and then you went into somebody's land. The doctrine of necessity allows you to be there because it will forgive minor violations of the law. Let's just say that the speed limit was 55 miles an hour and you did 65 or 70 to get away from somebody. The doctrine of necessity, if you have a good lawyer, the police won't charge you with speeding and they won't charge you for not being an innocent party. It's called the doctrine of necessity. But again, my situation, coming out of the Minnesota Twins Stadium, if you had a gun on you, you defended yourself, are you screwed? My name is Kate, and this is Castle Tutelage, your home defense network. I hope this helped. Maybe.